Thanks so much for attending. Hope you're having a great day. Today, we're going to go through some asset protection concepts, some cases, and then we're going to take a hard look at 3 Supreme Court cases that came out this year impacting federal tax, one of which is international. On the agenda, we work through some of the general LLC and trust concepts, and then we'll work through how those cases interpret those concepts and how our strategies are then molded to deal with the statutes and cases to get the best protections possible. And then we'll go into the Supreme Court update. First, some general points on asset protection. Obviously, we're intending to create structures for our clients whereby if they become subject to litigation, they don't lose the assets that they either hold in their own name or in trust. The idea is not to hide things. The idea is to create structures that are allowed under current law, both domestic and offshore, to limit the exposure. We basically have 4 areas of asset protection that we utilize in terms of tools for protecting what we have. We have titling. In other words, in what way will the asset be owned? In Florida, for instance, and actually almost every state has some form of it, is tenancy by the entirety, TBE. That's husband and wife ownership. A few states don't have it. These are called community property states. But TBE comes from the English common law in the 15th century, whereby if a father of a daughter pays a dowry, the idea was that that dowry went to daughter and new husband by the entireties. And it prevented the new husband from being able to sign and move that asset around without the daughter's consent. But the impact of that from a protective standpoint was that if someone sued either husband or daughter, not both, the asset was not available. And we have that in Florida and in a number of states. As I had mentioned, Florida is very protective in that it's very blanket. It's available for personal property, which is non-real estate, and real estate, intangible, hard assets, all land, buildings, etc. Many states offer it, for example, for real estate. And a few, like I said, don't offer it at all. So you have to figure out, okay, how am I going to divide the asset between husband and wife? We'll return to that issue with respect to LLCs and trusts. Exemptions, certain states allow the purchase of assets as exempt from creditors. There's no entity or trust required. Essentially, the asset is not available. So depending on how you purchase life insurance or annuities, for instance, or you create an IRA or deferred compensation account, that asset is not available to a creditor if you're in fact enter into litigation. It becomes fairly complex from state to state, and we'll have a section on choice of law. What law should I use if I have the option? In that insurance, for instance, is not protected from, in some states, creditors of the owner if the owner is not the insured. It becomes very technical. Like in Florida, if I own insurance on someone else as part of a cross-purchase arrangement, and I'm sued and there's a cash value to that insurance, it's not protected. So you have to kind of get into the details of a lot of this. And of course, there's a lot of litigation that arises from buying exempt assets, titling certain ways without guidance of a professional. The trust is a very interesting, as a third tool, asset protection measure, because what the trust does is it divides title. So the idea of titling an asset would be that you take title and you can benefit, sell, utilize, whatever, utilize the asset and benefit from it not just that you have legal title. So with the trust is it says, okay, in the trustee, we're going to give legal title. The trustee can manage the asset, but the beneficiary has beneficial title. The beneficiary can benefit from the asset, but only to the extent if it's a spendthrift trust that the trustee allows. So if the beneficiary is sued in litigation and the trustee says, well, we're not going to distribute any assets to that beneficiary right now, that litigation, that plaintiff cannot reach any assets of the trust. That's the creation of the trust fund baby. And again, depending on the jurisdiction, there may not be any exceptions to that. You just can't get to the asset. Some jurisdictions say, well, if it's an ex-spouse, or well, if it's a child for child support, you can break in. So if you're looking for the most protective trust, you've got to look for the most protective trust jurisdiction. And then we get into limited liability companies, basically business entities. We'll discuss the difference between LLCs and corporations and how that works and what the distinctions are between the different jurisdictions, domestic and offshore. On the business entity side, as background, you look at corporations. Corporations are used essentially to create a business pursuant to which anything that goes on in the business, about the business, suppliers, creditors, activities, accounting, is really just part of the business, and thus any creditor associated with the operation of the business can only reach assets of the business. This is a business promotional law. In other words, if you start a business and at some point you don't manage it well, or something unfortunate occurs or whatever, assets of the business are the only thing that are exposed to liabilities of the business. That's inside asset protection. In the business is in the business. You can't reach an owner unless there's some kind of fraud, or they're using the business for their own purposes, this type of thing. But that's how asset protection kind of works in business. We used to have partnerships, a lot of partnership. You can still form a partnership. I don't know why anyone would at this point, but whereby you had a handshake or you had a joint venture agreement, and the actual operations of the partnership business were a liability to the owners, which of course you never want anything like that when you can create a corporation or an LLC. So that was a problem, and people essentially avoid it now unless they just have no idea what they're doing. And then, but what we got out of the partnership side was that partnerships law did say that if I have a partner and the partner gets into litigation separate from the business, that litigation doesn't affect me as the other partner. Right? So the only thing that plaintiff can get from my partner is a lien on their interest called the charging lien. And that charging lien spilled over to LLC. So we moved to an LLC. These are the partnerships and how it kind of evolved into the LLC. What we get from the LLC is we get the inside protection. Something happens in the business, it doesn't impact the owners. But we also get this charging order concept whereby if an owner known as a member is sued, the plaintiff can only get a lien. Like in a corporation, if a shareholder is sued, they can take the stock, and then they can get into the company, potentially become a voting owner, etc. With LLCs and partnerships, if you sue an owner, you can only get the lien. That's the general rule. LLCs also offer the inside protection, where if something happens in the business, it's only the business assets that are exposed. And that's kind of why it's the preferred entity. Essentially, it's the entity now, unless you're going to take a business public or something like that. It's also a lot, we've got some benefits here with respect to the LLC. It's much easier to develop. You can create an operating agreement, which takes the place of both bylaws and shareholders agreements and this type of thing. There's no annual minutes. it's a lot easier to deal with. Now, of course, the drawback, the resulting drawback is that a lot of people form their own operating agreements, or non-lawyers create operating agreements, this type of thing. You got to be careful because it's flexible, you can do whatever you want. If you mess it up, it's your mess up. There's no backstop like a corporate bylaw statute, which is gonna protect anyone. It's a complete mess when these things are mishandled. We look at with LLCs, where are we gonna form it and why, right? What is the different laws? How do they interact? If we create a holding company, is the holding company gonna be formed in the same place as the subsidiaries? A lot of times the answer is no. So some states adopted this revised Uniform LLC Act. It's not very protective, actually. There are other issues associated with protection, and that's kind of become the pointed side of LLCs in terms of where you form it. For instance, if an owner sued, can that charging lien be foreclosed? Does it result in someone being able to get into the company? Well, we don't want to form in a jurisdiction that's less protective, so we've got to figure out where we're going, right? And these are kind of the issues we have.
Quick question. What about if an LLC made an election to be taxed as a corporation and files Form 1120? Would the same LLC protection apply in this case?
Yes. Yeah, the actual taxation of the LLC is not related to these state law protections or the offshore law protections. Now, we have one case in Wyoming, beautiful state I recently visited, by the way, whereby there was some confusion with that. There was a mention in the case called the Green Hunter case, where the subsidiary had filed to be disregarded for tax purposes. That had nothing to do with the state law protections over the entity. And this was maybe 12 years ago. And there was a suggestion that filing somehow weakened the subsidiary. So we kind of avoid Wyoming in that regard. Not to avoid going there, but avoid the LLC statute there. Wonderful place to visit, by the way. So no, it's not, it should not be in any way suggestive of protections. It's really a issue of when I form the entity, I'm allowed to be a corporation, an S or a C. If I've got more than one owner, I can be a partnership, or I can be totally disregarded. I could be like a sole proprietor also on the LLCs, and that should have no impact on protections. And that goes to this slide here. How do we fortify protections? Well, we may hold the LLC tenancy by the entirety and put another layer on top of it. You know, we'll get into the cases now, which are really helpful in kind of trying to interpret how to approach LLCs, where to form, what to, what format to use in terms of who's going to be an owner, and how to blend different types of tools into the LLC. On Wells Fargo, that was a woman who got into the real estate crash in Florida, had all kinds of problems, and started moving assets into LLCs, one of which was an offshore Nevis LLC, which I had a hand in drafting that statute. Very good LLC, but what happened is it was really a fraudulent transfer case. What that means is you moving assets in while you're running away from a creditor. Never really a great idea. We don't get involved in that as a law firm in general either. But when the Florida court looked at the case, instead of saying, well, she just kind of moved everything out, running away from the creditor, we can unwind that under the fraudulent transfer statute. They didn't do that. It created some insight into what courts may do. And they basically said, well, yeah, we understand it's a Nevis LLC, but the assets are here, she's here, we're really dealing with a Florida issue. We're gonna look at it as if it's a Florida LLC. Not sure where that came from, maybe from the Portnoy line of foreign trust cases, unclear. But it's interesting to see how far a court will go. And now we know, based on the number of cases, when an LLC or an entity is formed in a jurisdiction other than their own. So when we litigate these cases on the collection side, we typically want to be in the jurisdiction where the LLC was formed, especially if it's a protective LLC. That court will often be very respectful of the LLC protections, whereas a court outside the jurisdictions is much less protective. For instance, in this JP Morgan case, you had an Arizona litigation where someone with a Colorado LLC lost. There were assets in the Colorado LLC. They took the Arizona judgment and, not smart, went to Colorado. That's where the LLC was formed, and Colorado does have some significant protections of LLCs, and couldn't get into the LLC. They were in Colorado with the Colorado court trying to break into an LLC. That's harder. That's much harder than being in Florida trying to get into a Nevis LLC. This case, Arroyos, also very insightful with respect to the fact that you had litigation in Maine, in the state of Maine, that was moved to Alabama in a federal court regarding collection of the assets inside a Delaware LLC. And the court, I think the court was confused. The reality is that the Alabama court could hear law both based in Maine and Delaware and make a determination in an Alabama jurisdiction, in a venue, in a court in Alabama. But the court said, no, that's a Delaware LLC, and I am not going to rule on a Delaware LLC, and would not collect against that Delaware LLC. So extremely debtor-friendly outcome. Which is correct? We don't know which is correct. I think in some ways both are incorrect. I go through this with my partner my litigation partners all the time. What's correct? What's not correct? The idea a lot of times with asset protection structures is to make them as durable as possible. So if we know that Delaware is respectful of the single member LLC, doesn't have a weak link with respect to single member LLCs, for instance, well, maybe we use Delaware, and we can go to that statute and take a look. If we are afraid of the Florida statute, for instance, with respect to a single member LLC, what happened, we will get into that in a second, is Florida pretty much abandoned the single member LLC. Well, we stay away from Florida. Let's keep it as simple as we can on the law side and as powerful as we can on the structure. When we talk about single member LLCs, there was years ago this Ashley Albright case, but it was a bankruptcy case where in bankruptcy you have to be very careful because people with assets should not go bankrupt in general. So if you have an asset, basically the court is looking to say, look, you need to surrender your assets and we will discharge you of debt. It's not a regular court proceeding. Regular courts don't discharge people of debt. So you kind of give up the ghost a little bit. You're like, I got to get rid of this debt. I'm going to give up my assets. If you don't have many assets, it's kind of a no-brainer. If you have a lot of assets, it can be a significant decision to go bankrupt, usually the wrong decision, because a lot of times these debts can be worked out. Anyway, in the Albright case, it said, well, you're a single member of this LLC that we want to take. And this idea that if you own an LLC interest, that someone can just take a lien in it, that you're limited to this charging order lien, which was pretty clearly the law. we don't think that was the intent, so we're gonna say that on a single member, the plaintiff can go ahead and take the LLC, that this charging order lien limitation doesn't apply on a single member. So that's where it started in bankruptcy. And then, of course, you work through a number of cases. There were other bankruptcy cases that said the same thing. And then you got to the Florida case, Olmstead. Of course, it was a terrible defendant, a guy who had stolen millions of dollars through a credit card scheme. The court just was like anxious to get to these assets, and essentially dismembered the Florida LLC statute at the time to say it's just basically like a corporation. You guys can go ahead and take it. FTC took it, and that was the end of that. Florida had to completely rewrite its LLC statute. It's a pretty good statute, except lobbied in was pretty much an open-ended single member LLC exception. I mean, if you have an LLC that's a single member in Florida, it's pretty exposed. If you prove that you give regular distributions out of that LLC, maybe you can get a charging order limitation, but it's not it's definitely not a preferred jurisdiction for a single member LLC. And you have a number of, we listed here a number of jurisdictions now, Nevada, Delaware, et cetera, that specifically protect the single member if you need to go single member. In terms of cases, there are several cases, including this Glick case, where the court protects the single member, protects the idea that if the statute says, look, if you get sued, all there is a charging order. You can't get to the assets of the entity. The practical side is in this slide. We add members a lot of times. Sometimes we have a husband and wife that own tenancy by the entirety. You'd need a case against both husband and wife before you can get the lien. We add the kids. We add trusts for the kids. If we have a single person, we add the self-settled trust, which we're going to hit in a second. And this goes into some of the single member issues. This Kirchie case is quite enlightening. Essentially, it was a very wealthy person that had gotten sued. This Baldwin had been sued by Kirchie. Kirchie was kind of at his wit's end. He had lent money, or there was some kind of $5 million liability owned by Baldwin. Baldwin kind of stuck his tongue out at Kirchie and I think violated a court settlement. And the case was such that Kirchie wanted to get into Baldwin's family holding company, a Delaware family holding company with several $100 million. So the case starts, and Baldwin stops making distributions from the family holding company, which is the charging order issue. So if you get the charging lien and there's no distributions, there's nothing to get. California had a rule in place whereby it dealt with corporations. So if you sue a corporation, you can take the stock. So there was no what they call reverse veil piercing. Veil piercing is when you have a corporate debt and someone says, you know what, there's no assets in the corporation. I want to pierce the corporate veil. I want to get to the assets of the owner. It's very difficult to do that in Florida. Most states really limit that. That's veil piercing. Reverse veil piercing is, okay, this guy Baldwin owes me money and I need to get into his entity. I want to get into the entity and get to those assets. Well, California says you can't really do that at the time. But the case was based on corporations. Because corporations, it wasn't applicable. You could just take the corporate stock. And so there was an appeal. The appeals court said, you know what? We're looking at this, and that's Nevis. Let's just stay on this one. We're going to allow it. We're going to allow you to pierce the veil, because what's happened in this case is Mr. Baldwin owns 99% of the portion he owns with his wife. Wife owns 1%. Mr. Baldwin controls every aspect of this entity without exception. And he's starting to play games. So they send it back and they allow the piercing from the outside if you're playing games with this thing. So we want to avoid this. We always do. We always avoid this Curchi situation. If we hold tenancy by the entirety, well, we can in Florida. This was a Delaware entity. Delaware allows tenancy by the entirety. So you'd have to have a suit against both husband and wife. And we want to have trust for the kids. We have a multi-member. And we would assert Delaware law, probably not California law. My reading of that case was that none of that was done.
I have a question. So,
yes.
If you form a Delaware LLC, but the business is conducted mostly in Florida, does that change the protection of the LLC due to the fact that most of the business and with an office in Florida is conducted in Florida?
Well, it depends on the claim. So the claim here is not a business claim. Okay, so if in fact that claim, for instance, was inside of a Florida LLC, that claim recovery, if you win the litigation, is going to be limited to the assets of that Florida LLC. Unless there's some kind of playing around going on where they're not utilizing that Florida LLC properly as a business. Let's say you do have an alter ego issue where it's kind of the owner of the Florida LLC is playing around with paying their electrical bill, and you know, we had one where we had elective surgery paid out of the business, stuff like that. Maybe you can break through. Maybe you can pierce the corporate veil in Florida. Okay, so if you break through, now you can get to the owner. And like Corchi, can we get into Baldwin's LLC? Well, it depends on how he set up the Delaware LLC. If he set it up tenancy by the entireties and you only have a claim against one spouse, nope, you can't get in. If you have a claim against both spouses somehow, you can get a lien. Can you break that lien? I've never seen that. I've never seen that. So it's still probably very protected.
So this leads into another question. If you hold an LLC ownership as TBE, does it expose other TBE assets to claims that may occur?
No.
From activities? Okay.
No.
Another question here. Can you still be protected in Florida where the corporation is a limited partner of a general partnership?
Limited partners are not liable for anything that happens in the general partnership. That's the problem with general partnerships. That's why we don't do them anymore. The general partners are completely liable for everything that happens. So we can look at some offshore. We create a lot of offshore LLCs. We create a lot of offshore trusts. Typically, assets are held offshore, unless it's a business. Sometimes we have a business. We actually have a different branches and this type of thing, and subsidiaries we create offshore, and we use an offshore LLC. But if we're doing it for asset protection purposes, we're usually creating a trust. The trust has an LLC, for instance. That LLC holds a particular asset, and it's wildly protective. The law is very protective over these, not just because it's offshore, but the actual law is also very protective against fraudulent transfer, and the collection law is very tight. But the real basic reason is because the asset and the owner are offshore. Very hard to deal with that for a plaintiff. This goes into some of the issues and how to use offshore trusts and LLCs. Again, this Sabrina Barber case, very interesting. She was throwing assets in there, running away from a creditor. She kept the assets in Florida. Not a great idea. When we do offshore entities and trusts, there's the actual tax reporting changes, FinCEN, FATCA, etc. It's a little more cumbersome. Typically, you would have a wealthier client that deals with offshore asset protection. Here's the TBE. We mix that TBE on top, like Tony had mentioned, with respect to these LLCs to avoid even the charging order. And then we get into the self-settled trust, which is 20 states allow you to create your own trust that is protective of its assets. And that leads us into our next, I'm going a little quickly because I do want to do the SCOTUS update, and I know we only have 50 minutes. We're like 33 minutes into it. Okay. So this is just a background on trust. Trusts are basically putting assets with a trustee for the benefit of someone else. I put assets with my brother Joe, who holds the assets for my kid. And that divides title. Like I had mentioned, Joe controls the assets, but the kids benefit from the assets. You can do that in general with a lot of assets. You can have special purpose trusts. A lot of times some people come into the office with these revocable trusts and think that they have some protection. Revocable trusts provide no protection at all. And then you have these asset protection trusts. Basically, until about 1984, if you wanted to create a trust that was protective for yourself, you had to do it offshore. And we started with Alaska and Delaware, but now we have 20 states where you can create your own trust. So where we had a limitation essentially with the LLC, in other words, if we have husband and wife, we can create entireties owning that LLC with trust for the kids. If we had a single owner or not a spouse, but a single person with kids, the kids can be in trust, but the single person, if the single person sued, we had no way of protecting that interest from a charging order lien. So until we have these domestic asset protection trusts, which allow you to contribute assets to the trust, choose a trustee. We like Nevada, choose a trustee in Nevada. And Nevada says that asset may not be reached by creditors of the settlor, the one who formed and funded the trust. Very interesting, very protective, and under most circumstances that we found. If it's abused, it's not going to work. It's a newish thing. It's not new at this point, but it's a newish idea. If it's abused, if there's not a Nevada or a trustee in the jurisdiction where the trust is formed, if there's not an adequate connection to the jurisdiction, it may not work. And we can go through some of the cases. On this slide, we say domestic versus foreign. The foreign is more protected. The foreign is not subject to the Full Faith and Credit Act. In other words, if you get a judgment in any state, any other state has to respect it. We have defended the Nevada Asset Protection Trust against judgments in other states. It's not like you can't protect it, but it does create a means by which to register judgments in other states and then collect in those states, which doesn't generally exist in an offshore trust jurisdiction. And that's this 20 states, the Asset Protection Trust. You can create yourself. Florida does not offer an asset protection trust. It's largely untested in a setting, in the court setting. There are several cases, some are favorable, some are not favorable with the domestic asset protection trust. The unfavorable cases are usually abuses. Here are two. So in Huber, we had a developer who got into financial trouble, who had created a trust in Alaska. But the trust really failed to create an adequate connection to Alaska. That's number one. Number two, Huber filed bankruptcy. So bankruptcy really puts these asset protection vehicles to the test. you give up a lot of rights in bankruptcy. The judge can essentially move things around based on public policy. But it does give us some insight into what courts will do. Huber had a co-trustee that lived that was from Washington State, his state, in terms of controlling the trust. All the assets were in Washington State, all its connections were in Washington State, and the bankruptcy court was in Washington State. The Washington State Bankruptcy Court said, what we're going to do is we're going to call it a Washington State trust. And Washington State does not have a self-settled asset protection trust. And that was kind of the end of all the assets in the trust. So one major tip, if you've got a lot of assets in a domestic asset protection trust, talk to counsel about how that trust may be weakened or weak, and you may not want to go bankrupt. The mountain man Mortensen, in case number 2 here, did something which kind of accentuates that bankruptcy issue. He had actually done his own Alaska trust, asset protection trust. He did an okay job with it. He developed some creditors. He also had a divorce issue. But the way that fraudulent transfer works, in other words, if you create the trust and you start throwing things into it to run away from the creditors only have a certain amount of time from when they find out that you created an asset protection trust or have adequate information with respect to your planning to file a claim of fraudulent transfer. After that period of time closes, you cannot get those assets back out of the protective entity. In Alaska, I believe it was 4 years. So the time had passed, actually, by the time he got sued. And it looked like, from the way that the case progressed, they were not going to be able to get to those assets. But Mortensen files bankruptcy and opens up the statute to a 10-year fraudulent transfer statute. And that was the end of those assets in bankruptcy. Bankruptcy is really almost always to be avoided if you have assets. Some of these statutes require very strict compliance with affidavits and financials. That's this Bertrand case. You have to comply, or you will not have a protective entity. Erskine was a sham trust case where you cannot use the trust for either a bad purpose, and you have to use the trust pursuant to the statute. You have to have a trustee in place. That trustee has to have certain control over the trust. You can have a protector whereby the trust can't make a distribution. The trustee can't move anything out or steal anything or whatever without the protector signing off, but you have to follow the rules, and otherwise you expose the trust to being a sham and not protective. In this Kilker case, he had actually done a fairly sophisticated Nevada trust. He ran into trouble many years later after the statute of limitations had run, and the court didn't respect it. It's kind of an outlier case, but he was very disrespectful to the court and violated a court settlement. So you still want to be careful, even if you pass the statute of limitations on fraudulent transfer. And so the idea is, we create these structures. We might cap them with tenancy by the entirety. We might cap them with an asset protection trust. We might take an LLC and create more members with trust for the kids. Depends on the particular structure. The bottom line is, if you have assets and you might have an exposure, why not do it? Why not do it? The reasons at this point for not doing these protection structures are very minor. Here's some more on asset protection trust. In terms of the foreign asset protection trust, very, very protective, kind of like the LLC. Here's an old chart. It's the law is wildly protected because we actually went into Nevis, and then there was a guy who did Belize, and to chip away at these foreign asset protection trusts is very, very difficult. The idea, though, is that the assets are offshore and the trustees offshore. So they're not attractive to a domestic creditor. There is additional compliance with FATCA. You have to use a foreign trustee. There is some expense associated with that. Oftentimes, that doesn't mean that the trustee has any hand in managing assets. It really has to do with the trustee controlling distributions, but that you can have that protector there to create some security. This goes through some of the cases. We have to be careful with these foreign trusts, some of which are created at death. This Rush University case is very interesting. It was a very wealthy person who had left a lot of assets in trust and had previously committed monies to Rush University in Chicago. Rush sued, like, well, we can't get to any of this money, but he had committed, and we started construction already, and they won the case. They got paid. This goes back to, we just don't want to be stupid. Let's not create excess control. Let's not treat it as a piggy bank. Let's create some connection to the jurisdiction. Let's be smart in the way we create these asset protection trusts, these asset protection LLCs, such that when they're looked at by a court, there's really no weakness or very little weakness. And that's really what it comes down to. If you have any questions, my information is going to be at the end of the presentation. I do, however, want to go through some very interesting things that have happened. Shams, again, you're not going to use shams. You can't say, hey, I moved this stuff into a trust. Now I can't get it. It's impossible. That's all been debunked. There's some funny people have been put in jail. You go bankrupt, they put you in jail. You're going to release the assets in trust. They say no, it's impossible. They stay in jail. Actually, most of those cases where they stayed in jail, they kept the assets because you can't keep someone in jail forever. The Bilzerian case, they can threaten to put you in jail. Some people freak out and just start paying the judgment and stuff of thing. And the keys again are just be reasonable, create a connection to the trust. So on the SCOTUS update, the Supreme Court update, we've got three cases, three tax cases. You rarely see a tax case anymore. They're different. They involve totally different areas of tax law. One's international, but they are insightful, and they will affect, all three will affect planning. The first is the Connolly case. We have about 5-10 minutes here. Connolly case is an overturning of what was called Blount. And in the Blount case, they said, well, if someone dies and they own part of a small business, and upon their death, the company must take insurance proceeds and buy them out and redeem them. Well, when the deceased files their estate tax return, the value of those insurance proceeds in the company, which increase the value of the estate because the estate owned the stock, that value goes into the estate tax return. It doesn't count. You can offset the value of life insurance that the company get because they had to buy you out. It was always kind of a questionable decision because the life insurance on the asset side goes up in terms of the corporation, right? Even though there's an obligation to buy out the exiting shareholder, the deceased shareholder, it's still an asset. You could have an obligation to buy out a deceased shareholder with no life insurance. And what happens then is there's a promissory note. The promissory note now goes to the estate, and that's an asset of the estate, and that's subject to tax. So it didn't really make sense on an accounting basis. And that's what the Supreme Court thought. So in this case, you had Crown Supply. It was owned by two brothers. The 70% owner, 77% owner died. Life insurance came in. In this case, the other brother, the survivor, had the right to purchase. If the survivor didn't, then life insurance the life insurance that came into the company must be used to buy out the deceased brother, right? So you had a survivor who remained an owner, but the company got insurance proceeds. The insurance proceeds were then to be used to buy out the deceased's shares held by the estate. Blount said the life insurance doesn't count in the valuation of the estate. The Supreme Court said, no, they count. So we have to be careful with that. What does all that mean? What, when we have this life insurance in the company and it's used for the buyout, it means that you're creating estate tax on the estate side of the shareholder that died. So you got to be very careful with that now. And the way to deal with that is, why don't we do a cross purchase arrangement? Right? So instead of the company buying the insurance and increasing the value of the company, which is just going to go out to the estate, let's do a cross purchase arrangement. Let's not worry about like this idea of buyout and a consolidation of the shares. Let's go ahead and do a cross purchase arrangement where the two owners own insurance, and that insurance is then used when one of them dies. Now what happens? Now the survivor buys out the deceased estate. There's no value in the company added, and the estate tax doesn't go up. The second case is Moore. Moore's the international case. So in 2017, Trump created this Tax Cuts and Jobs Act. It's very complicated it's its own seminar. We've done the seminar on that. The GILTI tax, which is a minimum tax, inversions, and this mandatory repatriation tax, which means you've got to pay tax on income from abroad. So the backdrop is there are controlled foreign corporations. In other words, there are offshore entities that are controlled by Americans. Americans that own 10% in those companies, which overall are held more than 50% by Americans, right, have what's called subpart F income. If you don't own 10%, or it's owned less than 50%, it's not a CFC. The income stays abroad until it's shipped back. That's when you pay tax. If it's a CFC, it's controlled. This is when these issues come up. So this only deals with CFCs greater than 50% owned. These people own more than 10%. But the CFC law says if I reinvest the profits, the subpart F income, I don't have any tax. I don't have to pay any tax. So that was going on for years. It was a profitable company. The profits got reinvested. And so this was an example of mandatory repatriation under the Trump Act. So they had to pay, they were told by the IRS, they had to pay all these back years of tax. Well, it wasn't the law when they signed up for buying into this foreign entity. It's not an S corp, it's not a partnership. There's no pass-through. It's a CFC. It's an interesting case in that the case, and we're going to have several articles on this one. I think we're going to do for Florida bar. The case is essentially a constitutional law survey. It's a very long case whereby the majority says we really can't upend the idea of pass-through status. So based on partnerships and S corporations, etc., we're going to go ahead and allow the taxation for many prior years of this subpart F income even though that wasn't the law until the Trump Act. I thought it was pretty controversial, but it's over. The Supreme Court has acted. The claim basically was that it's unconstitutional. You can't tax people and assets. You have to tax income, essentially, is what happened. Originally, you couldn't tax, and then we had the 16th Amendment, which kind of allows indirect taxation, which means the fruit of the tree, not the tree. And the claim was that this was not the fruit of the tree, this was the tree. In that regard, this clearly seemed like the fruit of the tree. It just wasn't the law at the time. But the majority said it's constitutional and that they have to pay the tax.
What if the CFC does not have any subpart F income? Does the 965 still apply?
No, it still applies, but there's no income, so they don't have to pay any tax on it. The idea was that if we just kept reinvesting, we could avoid. So there's nothing to reinvest. There's no tax. And that's kind of the way the Moore case went. It's an interesting read from a kind of a geek out perspective, because each of the justices take their own constitutional position. One coming from Thomas, which works through the constitutionality of tax in general, which says this is insane that we're taxing people on something that they didn't agree to for years that have passed and closed, all the way to Justice Brown, who says we can tax whatever we want. Essentially, there's no limitation. Essentially, that's what she said. They didn't address these ideas of tax on wealth and capital gains, and there's your Justices Thomas and Brown. And then we have we're kind of going over for a couple of minutes. We've got the Loper-Bright decision, which is also a very long decision, but I will just do an overview here. Much of tax law is handled through regulation. So we have the tax statutes, which is the Internal Revenue Code, which is like maybe this thick. And then we have the regulations, which essentially interpret and guide the law, which are like that thick, right? So we had for 40 years the Chevron doctrine in place, which said to the courts, if in fact something comes up under the Internal Revenue Code and there's an ambiguity or an absence of law, and it's not unreasonable, you have to follow the statute. In a nutshell, you have to follow the regulation put in place by regulators, the executive branch, the collection side, the IRS. The IRS puts these rules in place which interpret the statute, and you've got to follow them if they're reasonable. You've got the massive regulation which really guide everyone in terms of how this thing's going to be enforced. And that's true in a number of areas. In this case, you had fishermen were forced by regulations. Let's see. I can give you the name. The National Marine Fisheries Service to have a monitor on board, which they had to pay for so that the herring industry did not overfish. They went completely nuts because of the cost, and got this all the way to the Supreme Court. But it applies to all regulations. So the majority, written by Roberts, said, no, we don't have to follow the regulations. The court applies its independent judgment. We can look at the regulations, and it's a factor, but it completely upended this idea where the courts must follow the regulations. So you're going to have a wave of challenges now to different areas of law that were once really in many ways subject to regulations. And that's it.
I have one question here.
Sure.
For a foreign individual that did not become a US shareholder until after 2017, the individual resided in his country of origin until 2018. Then he moves to the US. My understanding is that the 965 does not apply since the person was not a US person in accordance with the IRS code. description of what constitutes a US person. Is my understanding correct?
I believe the interpretation at this point is that you had to, this is brand new, this looking back at this, is that when this income was incurred, you were offshore. So when the income was incurred, it was not subpart F income. You were a foreign shareholder. When you came in, you became a US shareholder. If you know, let's just consider you a US person. There's a whole set of questions I'd have to ask you for that. Let's say you become a US shareholder. At that point, you would have subpart F income, and you would be subject to the pass-through for non-reinvested income. But my understanding, I've never looked at that particular issue, but my understanding is that because you had no subpart F income during the years associated with the mandatory repatriation tax, you wouldn't have to do it. I hope that helps.